Showing on this episode of Law Weekly, we discuss mainstreaming gender issues, law and security. We have the views of the first female dean of the Faculty of Law, University of Lagos, Professor Chioma Agomo. The Minister of Justice and the Attorney General of the Federation, Mr. Abubakar Malami, is calling for unity irrespective of the challenges that have faced the country in recent times. We also have our recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Shola Shuyeli. My guest, Professor Chioma Agomo, is the first female dean of the Faculty of Law, University of Lagos. On March 1st, 2021, she will bow out of the university as she retires after clocking 70. Several events have been lined up to herald her celebrated exit from the ivory tower after over 40 years of unblemished service as a foremost law teacher and expert. In this interview, I began by asking how this makes her feel after a career that saw her become not only the first female dean of law, but also the first female elected dean of a faculty since the establishment of the university in 1962.
Fulfilled. I feel very happy, and I am very, very amazed at God's amazing grace, because it's all been a work of grace. It's been God all the way. So I'm happy and I'm satisfied.
As a former Dean of Law and member of the Council of Legal Education, are there any gaps in the training of lawyers in Nigeria in the light of new technologies, virtual court proceedings, etc.? Can you share with us some of the gaps that you've identified?
It's hard to say that there are no gaps or that there are gaps. I would say that Nigeria is also trying to measure up. For example, here at the University of Lagos, we have commenced lectures, but they are all virtual, including the Faculty of Law. In fact, the LLM at the master's program, the report I get that it's been a resounding success. So I would say that legal education is trying to pull its weight to follow up and meet up with the times.
I have read that your secondary education was interrupted in your final year in 1967 by the Civil War. So in the light of Nigeria's current security challenges, do you think that there's any role for law in addressing this crisis?
I think that's $1 million question. My opinion is that you can make all the laws you like. It takes people. First of all, people make laws and people implement laws. So law is really a reflection of the people. And if nothing changes, if the mindset does not change, you can make all the laws you like. Nothing is going to change. Nigeria is what I will call an ethnocentric people. So it beclouds our judgment as to what makes for good law, good governance, and the welfare of the totality of the people. So law can only be a reflection of its people. And I would say, men and women, people must first change. Before anything can change, we need to have a rethink. The mindset, we have to change.
I know that you're also passionate about mainstreaming gender equality. How much progress would you say has been made in that direction?
I think this is an area where we'll talk of maybe one small step forward, maybe back. It's ding-dong affair. But one area that maybe I would say that you can have or you can see the change is the area that women are now beginning to tell their story, not others telling it for them. In other words, this victim mentality, are they done to us? No, you take your future in your hands. You may have been a victim or victimized, but you now use it because you can get up and tell your story. And in telling your story, you get power, you get freedom, and your voice can be heard, and your voice resonates. So you find people, it connects. So to that extent, yes, there's been progress. But when it comes to different areas, employment, governance, or whatever, I think it's tokenism. I think people still talk, but they don't follow with the talk. They don't follow through.
So what has to give? What has to change?
It still goes back to the same issue of people need to change the way they think. We must be ready to unlearn so we can relearn. In dealing with gender issues, we find that the iceberg concept is very true. That is submerged in our culture, in our religion, in socialization traditions. And people talk about them as if they are cast in stones. But they change. And so we need to change the way we think, the way we do things. And see, like I say, every human as your equal. Men, women. We are all born equal before God. So to think that because you are born male, you have a superior right over me, that's what you have been taught. That's what you've been socialized to come and believe. I think it's wrong, terribly, terribly wrong. The moment we begin to change it, you find that, in fact, we've just changed ourselves and say, why did we remain in the dark ages for so long? We have so much to gain by working together as partners in progress. We need to come to that understanding that it's about us, it's about the community, it's about the nation, it's about everybody, it's about our well-being. Then I no longer see you as, after all, you're just a wife. After all, you're just a girl. You're not supposed to do that. You hear that so much. A married woman. Does it define you?
Very profound words there, Prof. I hear what you said about the need to unlearn and relearn. But what advice would you give to young women, young professionals, a lot of who look up to you as a role model, as a mentor? How should they deal with discrimination on grounds of gender?
Okay. I say I'm a storyteller. And anybody who comes to me, I said, you have become part of my story. And I hope that I too have become part of your story. Now, when I was dean of the Faculty of Law, one day I was in my office, a student of mine came in looking haggard, traumatized, everything. And then I asked, I said, what's the problem? Of course, it's a marital issue. Her husband had 2 wives, and she had 4 girls. And so he had left her to her fate. She and her children, she was solely responsible for these children. And she was overwhelmed. But a colleague of mine, my very close friend, now took on one of her last child to stay with her, to help her to be able to concentrate. So when she came looking, like I said, the victim, the perfect victim picture, and I said to her, just because you have been rejected, is that why you should reject yourself? And I said, would you really have passed, I have passed through that stage? And if I can pass through that stage and I'm sitting here today, why should you be different? She looked at me and she pointed at me and started laughing hysterically. So I was watching her, then she left the office. The next day, she came back, dressed up, neat. And I said, do you want to see me? She said, no, I just came to show myself.
Wow.
And I said, the last contact I had with her, she was doing her master's. There are many like that, people who come and say, do you know this man has not touched me, meaning husband, for the last 2 years? Do you know he picked another woman who is in this same place with me? I see her every day. And I said, well, we just have to move on. And years later, I see her, they're reconciled. She's happy and all that. The last I heard of her celebrating is 20 years of marriage. So you see people who, like I say, storytelling, the fact that something has happened to you does not mean that that thing defines you. In fact, that is a wake-up call. That's where you should build on it and say, so what?
What next?
What next? But if you think that your future depends on someone being accepted, then you'll be there. And at the end of the day, you'll be really the real victim, but victim of your own inactivity, of your own, what I call self-prison.
Let's also talk about another of your passion. I know you're passionate about the practical application of human rights principles in the world of work. How has that journey been so far?
Oh, it's one area where I would say Yes, I can see a lot of positive changes. I have worked closely with the National Industrial Court for almost 3 decades, and I've seen the transformation that they are making. When we talk of the world of work or labor relations, we have 2 levels: the individual employment law and the collective employment law. I think we've had more, and that's where the human rights issue play out more, within the individual employment law area than the collective. Because before the National Industrial Court got its wider powers, the individual employment law cases went to the regular courts. And our law is based on English law that says freedom of contract, non-interference. Employer can hire and fire for any reason or for no reason. So you can do anything you like, you're just an object, as it were. It's no longer so. The ILO concept of decent work means that you have to, labor is not a commodity. The issue of Chapter 4 of our Constitution or Chapter 2 not being justiciable no longer applies, because Chapter 2 has been used by the National Industrial Court more than once to enforce the fundamental rights of workers. And with the phenomenal case, the land-breaking case of A.J. Maduka, the first case on sexual harassment, where the judge used the Constitution, CEDAW, African Charter, everything to rule on that case to establish sexual harassment. I would say, yes, I'm satisfied. But that does not mean that we have arrived at the bus stop, no. Like the National Industrial Court, they had a workshop last month, and they asked me to come and share my thoughts, passing thoughts, where do I think we should be heading to? And as God will have it, even some judges of the Court of Appeal were there, and the Court of Appeal had just delivered a landmark decision, and I said, my fear had been that the Court of Appeal was likely to pull back the National Industrial Court. The progress made was like it was in danger, but no, that decision was a refreshment. It was like a breath of fresh air, saying we recognize this court as a specialist court. They have areas, so we have to listen to them when issues like that come. That means we have come a long way. And also is another decision of the National Industrial Court saying the common law rule that says you can't say an employee go back because it's in the private sector no longer applies. It doesn't mean it has become a general rule, but what it means is that private employment relationship is beginning to inch nearer to public employment law rules. And that's a big progress. That's a huge progress.
Beyond this area that you've talked about, I know that you're an expert in both contracts and labor law. Are there gaps in those areas that you think needs to be addressed?
No, like when you talk of contract, it's this issue of freedom of contract, that what you decide is what you will, you get what you see because that's what you decided. But the truth of the matter, for example, in the case of labor law, that's where the change is very important, is that there's really, in truth, no freedom. I call it Hobson's choice. You're looking at the devil and the deep blue sea. There is no real freedom. One, because of unemployment, a whole lot of activities, individual employer and employee don't get to sit down to determine their terms and conditions. It's only in very few cases. In other areas of the law, it's a question of law on paper and law in action. They are 2 different things. It's a question of the soul of the law manifesting. You can have, yes, we have law on paper. So what? Like many years ago, when I went to Turin for the first time, the International Labour Organization Training Center, and we had to bring a write-up from our different countries. The other participant from Nigeria brought his own, saying, oh, we have laws, we have this, we have that. I said, if you open your mouth, I will challenge you. We have the laws, but what effects? It's not about having things on paper. It's about how they've translated into action. I think that's what's beginning to happen, for example, with the amendment of the Constitution that enlarged the jurisdiction of the National Industrial Court. In other areas, if we can allow the spirit of the law to play out, then you will see the results. That's why, going back to the first question you asked, whether law has anything to do. What is the rationale? What mischief are you trying to cure? What's the problem? It was because we still haven't even asked ourselves, what really is a problem? Like I said, ethnocentricity, a problem. The way I put it, I said, the way we reason, you determine, okay, I'm Igbo, we want Igbo president, whether it's a goat or whatever, so long as Shebi Igbo goat, let him be there. Yoruba goat, let him be the Hausa goat. Shebi's Hausa. It should not be. We should be looking for the right person, the right woman, the right man for the job. Where you come from should not matter. But it matters to us. And because of that, merit is subsumed. Law cannot help you to do that. We have to change our minds. Something goes round.
Welcome back. Nigeria's Attorney General and Minister of Justice has made a call for unity. He made this call in Abuja at the launch of the book, Contemporary Issues in Nigerian Law and Practice, a refereed publication in his honor. The AGF insists that the country would remain one according to the Constitution.
Recent events orchestrated by the few unscrupulous and unpatriotic people cannot and will not undermine the constitutional status of Nigeria as a sovereign, united democracy and nation. It is instructive in this instance to remind us of the provision of Section 2, subsection 1 of the Constitution of Nigeria 1999, which stipulates that Nigeria is one indivisible and indissoluble sovereign state to be known by the name of the Federal Republic of Nigeria. In light of this, there can be no better unifying index underpinning national unity than our Constitution. The significance of the public presentation of the book should be seen more of an academic and legal investment for posterity to continue to benefit from the pool of scholarship that comprises the different chapters of the book. The advancement of knowledge is what will significantly propel Nigeria into a knowledge-based economy.
Away from that event, let's bring you a quick recap of what's transpired at some of the judicial panels across the country.
The National Human Rights Commission's Independent Investigation Panel has been asked to compel the Nigeria Police Force to pay a compensation of 200 million naira to a petitioner, Kingsley Kalu, who allegedly lost his left leg as a result of accidental discharge from the rifle of a police officer from the FCT Police Command. At the resumed sitting of the panel in Abuja, Mr. Kalu explained that his left leg was amputated in 2017 after there was an accidental discharge from the rifle of Mr. Daniel Akpabio, who has since been dismissed from the force. Mr. Kalu, who's also asking for a refund of all the hospital bills procured by him and an artificial limb, claims the police only gave him 150,000 naira since the incident occurred. The lawyer to the police has opposed the request for compensation. He insists that the right person to compensate the petitioner is the dismissed officer, Daniel Akpabio. In Lagos, the State Judicial Panel on Restitution for Victims of SARS and other related matters has summoned the Inspector General of Police, Mohammed Adamu, the Commissioner of Police in charge of Legal Department, Abuja, the AIG Cooperative Police College, Ikeja, and the Surveyor General of Lagos State. Justice Doris Okuwobi summoned the four in relation to a petition involving a bedridden 76-year-old petitioner, Prince Adewanle Adewuyi, who appeared before the panel. The petitioner is alleging police brutality, aggravated assault after his 26 acres of land in Badagry was forcefully taken over by the police in December 2013. The land is said to be worth over 800 million naira. His lawyer, Debo Adeleke, told the panel that the police has continued to frustrate the efforts of the petitioner to retrieve his land despite the recommendations made by the Citizens Mediation Centre, CMC, of the Lagos High Court. The lawyer urged the panel to summon the IGP and the other police officers, as well as the Surveyor General, who will show that the petitioner legally acquired the land. And in Osun State, a petitioner, Mr. Teslim Ibitoye, has narrated how he and his younger brother were shot by police over an offence they knew nothing about. He alleged that he was shot 3 times at different parts of the body by the police, while his younger brother, Akim, who sustained degrees of gunshot injury, died. He and the wife of the deceased have asked the panel to order the police authorities to release the corpse of the deceased, which has been withheld and kept in the morgue since 2017.
And on the home stretch, we bring you a recap of some of the activities from the courtrooms.
We begin with the report that a federal high court sitting in Abuja has fixed the 16th of March to hear an application seeking to restrain Mr. Mohammed Adamu from parading himself as the Inspector General of Police. Justice Ahmed Mohammed fixed the date to enable lawyers in the matter perfect their briefs before the court. In the suit filed by an Abuja-based lawyer against President Muhammadu Buhari, the Inspector General of Police, the Attorney General of the Federation, and the Nigerian Police Council, the applicant argues that Mr. Mohammed Adamu's tenure as the Inspector General of Police elapsed since the 1st of February 2021 by virtue of the Police Act. Still in Abuja, another judge of the court has adjourned till April 20 hearing on the suit of the former governor of Abia State and Senate Chief Whip Senator Orji Kalu seeking to stop his retrial on allegations of money laundering. The adjournment is predicated on the fact that the Economic and Financial Crimes Commission, the EFCC, which is listed as the first defendant in the suit, was not properly served with the originating summons. Senior Advocate of Nigeria, Rotimi Jacobs, who announced the appearance for the commission in protest, drew the attention of the court to the fact that the originating summons was served on his chambers instead of the EFCC. He told Justice Iyan Ekwo that he was yet to be briefed by the EFCC and it will amount to professional misconduct to accept court documents on the matter. Justice Ekwo then directed that the commission should be served within 7 days while the suit was adjourned to April 20 for hearing. Staying with money laundering charges, another judge of the Federal High Court, Justice Okonabang, has dismissed the fresh bail application filed by a former chairman of the defunct Pension Reform Task Team, Abdulrashid Maina, on the ground that it lacks merit. Justice Abang, in his ruling, said though it was at the court's discretion to grant bail, the former pension reform boss did not deserve a fresh bail after jumping the first one. The judge also said that Maina did not place sufficient materials before the court to convince it that it deserves a second bail. And we round off with the report that the Imo State High Court in Owerri has ordered an interim forfeiture of all the properties said to be illegally acquired by a former governor of the state, Rochas Okorocha, while he was in office from 2011 to 2019. Justice Fred Njamanze gave the order following an application brought by the state government. Some of the properties listed in the suit include the Eastern Palm University Oboko, the controversial Royal Spring Palm Hotels and Apartments, IBC staff quarters said to have been illegally acquired for the purpose of Rochas Foundation College Owerri, magistrate quarters, among others. In a related development, 14 persons said to be aides of the former governor have been granted bail following the arraignment before a magistrate court in Owerri by the Imo State Commissioner of Police Nasiru Mohammed. They were granted bail in a sum of 5 million naira each. The defendants were arraigned over a 6-count charge bordering on conspiracy, disobedience to lawful order, unlawful destruction of the official seal of the Imo State government, conducts capable of causing breach of peace, unlawful possession of firearms, and a defamation action on social media against the governor of Imo State with intent to injure the reputation of the state government and the person of the Imo State governor, Hope Uzodinma. Further proceedings have been adjourned till March 18th.
And that's our program this week. Don't forget that you can find these and past episodes of the program on our YouTube page. I am Shola Shayeli. Thank you for watching and see you next week.